UK immigration brief questions. Anyone coming live can ask their questions. I'll be live for about 15-20 minutes or so till my phone battery is active. Anyone coming live can ask their questions on UK visas, anything that I can answer in 1 minute, 30 seconds to 1 minute. I will try and answer those questions. I'm still waiting. In the meanwhile, I will answer some generic questions that I have on the channel. Here is it. Okay, hi Abdul. Okay, so one question I have is, what about people who are on 26,200 applying for extension after 4th April? What rule applies to them? So someone who is already on the skilled worker visa and the base for, at the time was 26,200, they will be subject to a base rate of 29,000. If they are extending, changing employer, applying for ILR, anything, 29,000 instead of 26,200. That is the answer. What are the questions? So someone has asked, you earn 29,000 on graduate route visa. I have a dependent. So you have a dependent husband and kids. Do I need to meet 38,700? No, the 38,700, 29,000 financial requirement. The video that the question is asked on is about spouse visas for British people and settled people. It does not apply to graduate route holders, skilled workers or anything. The financial requirement of 29,000 does not apply to points-based visa holders. Anyone joining live can ask their questions. I have about 20% of battery remaining on my phone. I will try and answer as many questions. Okay, what other questions do I have? Okay, about pre-settled status of European nationals. I mean, what is the question? What are pre-settlers with the same case? Okay, so someone who is, so if you have pre-settled status under the EU SSU settlement scheme and you leave the UK continuously for a period of 2 years and you never return back, then as per the rules, your leave can be curtailed. So basically, legally, you don't have any right to apply for settlement status, etc. Home Office is not actively stopping people as at this point, but definitely in future they do have plans of slowly looking at individual cases, looking at the data entry and exit records at the airports, and then slowly stopping people from entering the UK who are on pre-settled status but have left the UK for a continuous period of 2 years. So it's called as lapsing. So their pre-settled status lapses if they leave the UK for a continuous period of 2 years. So yes, the question is, what about pre-settled status with the same case? Someone who leaves the UK for 2 years, if a person lives outside the UK, you may have, currently I don't think Home Office is stopping people from entering, but in future, yes, they do have those plans. Abdul, live question. I'm a 29-year-old, I have pre-settlement status and dependent on my uncle who is Italian. I have pre-settlement status. I want to apply for settlement status. Yes, you can apply. Yeah, so what is your question? God costs from care home. Okay, one important thing. I do get several calls and inquiries regarding students who have failed their dissertations or something, course is not completed, but it is about not about skilled worker visa, it's about switching to graduate route visa. I know some lawyers or representatives, I don't know, individuals are doing it themselves. Some of them are applying for that fee waiver application, which is not at all relevant for you. It's only for human rights. Don't do those fee waiver applications just to buy time if you have failed. Second, people are filing those FLRM applications, which are quite expensive. You pay IHS of about 2.5 years and the visa fees also. and I don't think that is also recommended. I would not recommend that. In the past, yes, individuals where they have failed a course and they are doing a resit, if it is within a reasonable time, let's say within 2 to 3 months of their student visa expiring, it is possible to apply for the graduate route visa, keep it on hold. There are different ways to do it. I know I myself have done it, our team has done it, and we've got it successfully. But make sure you are going to pass the receipt. That's number one. Only then spend your money on the graduate route and holding that application. You will have to pass the receipt, number one. And once you pass, you may need a letter from the college confirming, university confirming that you have passed your course of study. So that is very, very important. Yeah, I have done that, several of them, I know. But I would always advise against filing those FLRMs and trying to vary them. Okay, I've already got a warning for my battery low. No live questions coming in. By the time I will take some questions on the channel. Another question about dependent visa. These are the common line of questions that I'm getting on the channel in the comments. So I'm just trying to address them together. Uh, One question that I see is a student who has not a student who has not yet completed the course of study has a dependent. The dependent is allowed to switch to a skilled worker visa. There is no restriction. I've checked it in the immigration rules several times, and I've advised people also, and have also done applications where the dependent can switch without the main applicant completing the course of study. The main applicant, if they don't complete, they may have to go outside the UK, come back, do an entry clearance, and join the dependent. So become a dependent. Basically, the main becomes dependent, dependent becomes main. So that is possible. Uh, I have done it myself. I know in around March when the rules were changing, we switched a care worker dependent into the care worker. No, a student dependent became a care worker, and now we are filing the main student. He is completing his course of study, and the children also we are filing and switching them to make the dependent of that of the main applicant on the skilled worker visa. So switching the dependent and the main. So the dependents can switch. I know several people have got emails from caseworkers saying that, oh, you are a dependent, you are switching to skilled worker, but we still need evidence of the course completion of the main applicant. That is not right. It's just some overzealous caseworker. As per the rules, they cannot do that. But I know overzealous care workers may ask some unnecessary documents. It's the new care caseworkers are there, they don't have proper training or whatever is the issue, or they just try to apply it across the board. So this is a common mistake that case workers are doing. It should be challenged. Go to take a legal representative and get through and maybe explain it to the caseworker if they are asking for any proof of course completion for the dependent. If the dependent is switching, they should not be asking that. Okay, can I apply settlement status without uncle applying for settlement status? What documents? I don't think you can apply without your uncle applying for settlement status. The main, your sponsor has to apply for settlement status. You can may be able to apply together or with them, but or after them, but I don't think you can. So next question I have on the channel is my husband. Okay. Anyone coming live can ask their questions. Okay. General questions. Okay, I don't see any other questions coming through. If anyone has any questions, you can ask them now. About the 20 hours supplementary employment, very important. I think I've made several shots on that, but just to address that, I know I keep on getting questions on that one. So every skilled worker, whether you are on tier 2 general visa, skilled worker visa before the 4th April changes, or skilled worker visa now, any skilled worker, any tier 2 general visa holder, 20 hours supplementary employment is allowed for everyone, where in any skilled occupation, not in any occupation. I know people are asking me, can I work in a car wash? I don't think so. It's a skilled occupation. Skilled occupation is an occupation which can be sponsored for a skilled worker visa. That's how I would define it. So only skilled occupations. Also, one more important caveat is you can only do that supplementary employment if you are doing the main employment, the main contracted hours, 37.5, 40 hours, whatever that is. You should be working with your main sponsor. Only then you can do the supplementary employment with any employer for 20 hours per week in a skilled occupation. Third question generally I get about doing business. Even home office, I remember I was on the call through ILPA and we did ask that home office case working manager, quite a senior manager, and they were not very happy about individuals doing business on those 20 hours. It was quite clear, I'm pretty sure, and that was the vibe that we definitely got, that the home office is not happy with individuals setting up their own businesses, because the main reasoning behind that, the rationale behind that was that if you are doing self-employment, how many hours you are working for that self-employment, it cannot be monitored. It's impossible. Whatever you can do, you can claim whatever, it is impossible to prove how many hours you are working in your own business. Hence home office is quite against individuals setting up businesses. I know somewhere on that skilled worker one liner is there, your business or something, it is on a very special category. For example, dentists have a special way where they can be self-employed under a skilled worker category. So for them, they may have a supplementary employment with a dentist. So that's a very small exceptional category. I know people are reading that as a general rule that anyone can set up business. Skilled workers who are employed, salaried, usually 99% of them, they cannot set up their own businesses under the 20 hours of supplementary employment. That is another point that I get a lot of questions on that I want to address. What else? Okay. I will be live for 5 more minutes. By the time my phone will die. Okay, what else? What else? Okay, another thing, we don't provide sponsorship. We are just immigration lawyers, so we don't provide employers, sponsors, anything. I know that is a general line of questioning that we do get. Third, yes, we do manage sponsor licenses and everything, but we don't give sponsorships and all. Okay, what other question can I take? No live question yet. Anyone coming live can ask their questions. And please, if your answers are, if you do like this live, do give a like, thumbs up. If you don't dislike, give a double dislike, so that you make your point and I understand that these are completely worthless lives that I'm doing. And do support our channel, become a member, become a paid member. It's just the cost of a coffee, and subscribe, and it will encourage us to do more and more videos. There are new series that we have started now, which is how to fill up an application form. So as soon as I get some more time, I will do more applications. Maybe last week we did release two of them. One was how to fill up a visitor visa application from anywhere in the world. It's quite a common application. People make mistakes, many are refused. So yes, that's one. And another, skilled worker application inside UK. So these were the two main that many people were asking questions. I was seeing refusals, issues and all. So I thought of making those two videos. So slowly maybe I will build up and make more videos on how to fill up application forms. It takes a lot of time, so I need a big chunk of time to do that. Okay, so yes, do support our channel by becoming a subscriber, paying just a price of a coffee. I think there are 10 members now. Big shout out to those members who are supporting us, and it will encourage us to make more and more videos and make as much information and immigration advice free as possible. So that is the goal that I'm working towards in the next 10 years, to make all the information free. What kind of questions asked to skilled worker visa at the airport? Generally, they would ask, how did you find a job? They may check. This is what I have heard from other clients, employers, and applicants, everyone, all the knowledge that I have. How did you find this job? Was there an agent involved? Any proof that you can show? Email communication, WhatsApp communication, what you had with the employer, everything. They can go into anything. how are you qualified for the job, how many interviews were there, etc., etc. They can go into how a normal job person gets hired. There are rounds of interviews usually, how was the offer letter sent, etc., etc. So they can ask any employment related questions as to how you found the job, or and how the employer found you. If it is a referral or something, yes, they will definitely go into further. If agents are involved, they will go in more questioning. I am very, very positive on that, to make sure that there is no abuse of the process, there is no selling of the visas. That is what they want to avoid. If they feel anything like that, uh, they will refuse entry. They have refused entries to many students also. I'm aware they do that on an ongoing basis. Uh, I speak to immigration officers also, so I know, I understand what their concerns are. So if they feel that you are not a genuine student or a genuine skilled worker, then yes, they will stop you at the airport, send you back. You will lose all your fees because your visa is approved and then cancelled. No refunds. Bharat, my stepfather living in the UK. I am non-EU citizen and 21 years can apply as join. You can just join your stepfather. You need to show dependency, and considerable amount of proof is required. Just having a stepfather he will not be able to sponsor you to be a pre-settled status or a family permit holder. Vishal was told that one cannot get new entrant visa for more than 2 years, but my course and skilled worker visa I issued for 2 years and 8 months because I had 8 months left on the PSW visa. Okay, the immigration rules don't provide that, I'm pretty sure. But yes, if you have got that, thank you for letting me know. If you filed 8 months before, how did they calculate? The immigration rules still don't provide that. I'm pretty positive on that. But if you got 8 months, yes, that is new information to me. It may be a case working error or it may be the case, but I need to see in the rules. Other than that, it's difficult for me to. I can only advise what is written in the rules, not because it says permission. It doesn't say how much you have used. There are other rules where it says how much of the visa has been used, but under the rules, whatever the reading of the rules, it says grant of permission. So very good if you have been given 2 years and 8 months. Okay. I have been in the UK for 22 years, but I'm illegal. I'm not sure if it is better to apply for something. 22 years illegal, you can apply. 20 years, we do get applications. You don't have to come to us. You can go to any other immigration lawyer, but do it through lawyers. I have done many cases of 20 years successfully. Uh, just have some evidence of living in the UK. It can be anything. I know it is difficult for overstayers. If you don't have anything, go without it also. All these things can be proved at an appeal. Judges are more, if you don't have anything, I don't think Home Office will refuse it. They may take some time to decide. But yes, if you at least you have the first passport you entered into, I'm not sure if you destroyed that or whatever has happened, but something to show that you have been in the UK, maybe you had a visa before. So I'm answering Patty's answer. So you have been in the UK 22 years illegally. If it is better to apply for something, you should apply for something. I would say that it is home offices may sometimes you may just get caught, and it may make things more difficult when you are in detention or any such issues start on you. So if they start any administrative removal or anything like that, so rather file an application, speak to an immigration lawyer. You can book a consultation with us. If you want to book with us, there is links and are in the description on our channel, or speak to any other immigration lawyer who has a good reputation of doing these applications, and go take it from there. But I would strongly advise anyone who has not completed 20 years not to apply for the 20-year long residence, illegal people, overstayers. But someone who has completed, definitely put in an application. That is my advice. I know other lawyers may advise you otherwise, even 16 years, 18 years. This is something that I always tell people, don't apply. You will lose all the fees. Home Office will be behind you as soon as they refuse the application. That's what they will. There is an enforcement team, and it will be a problem. But if you have completed 20 years, then I don't think you need to worry. Take it through the solicitors, lawyers, and yeah, file it and regularize your stay. That's what I would say. Okay, my phone battery is going to die now. Okay, this live will be saved. Thank you, Patty. Thank you. Good luck with the application. And do subscribe to our channel. I think everyone would have subscribed. Become a member and do support our channel. Thank you very much.